Hello, my name is Jim Herman. I've represented Social Security and veterans disability claimants for the past 25 years. And today I wanted to give you an idea of what to expect at your hearing. I can be reached at 800-900-4440, 800-900-4440, or by email wjherman, Hermann, @gmail.com, one R, two N's, wjherman@gmail.com. Your hearing's coming up, and so you're probably nervous about that. One of the first things I want to tell you about your hearing is don't worry about being nervous. You're not going to be at a hearing, whether it be by telephone, video, or in person. You're not going to be there to impress anyone. Your goal is one goal. Your goal is to demonstrate to the administrative law judge why you are not able to work full-time on a competitive long-term basis, and that's it. So please don't take medications or whatever to kind of jack yourself up, so to speak, to prepare for your hearing and to try to settle your nerves. You need to remember that part of what we're trying to show at most disability hearings is that you may have either a marked limitation or an extreme limitation. I apologize for reading this, but a marked limitation is, in other words, you're functioning on a marked limitation. You may need some outside help, you may need more help from family members with regard to accomplishing tasks in that category, and that you have serious limitations with regard to, and as a result of that limitation. Extreme is essentially you're so limited that you're not able to function by yourself. You may need either family members or friends to help you on an ongoing basis, or in some cases you may have a case manager that works with you. And in just about every hearing, we're looking to prove that you have either a marked limitation or an extreme limitation. Now, basically, there are three ways to be approved for Social Security disability benefits. Number one is to meet a listing. Listings are definitions that doctors have written up over a period of years, and definitions, and typically to meet a listing, it's very helpful if we get a statement from your doctor saying you meet that listing, and we can provide you with forms showing that what the definition delineates, and then your doctor is really going to be the best person to determine whether or not you meet a listing. So that's going to be incredibly helpful if we can get I understand doctors and all human beings, we're reluctant to we don't like to fill out forms, we don't like to do things of that sort, and your doctor's probably thinking, well, geez, I probably don't get paid for doing this, and I've got a room full of patients waiting to see me, and I recognize too that the average medical visit nowadays is typically 7 minutes according to the research. If your doctor doesn't want to fill out a form, say, well, doctor, if you don't mind, just send me a short letter just saying, what my diagnoses are and why that limits my functioning. Social Security, the common term that you see over and over again in Social Security disability is function. How does it limit your function? And eventually we'll get to what we call, and explain more about it, what they call the residual functional capacity, abbreviated as RFC. And we'll talk in more detail about that in a little while. But if your doctor or treating source, understandably, is reluctant to complete a document or a form, or even write a letter, say, well, doc, if you don't mind, just pull out your prescription pad, write out a very brief summary of what my most significant diagnoses are, and how you, in just a few words, think that limits my functional capabilities. The second way to be approved for Social Security disability benefits is to what we call it gridding out, or meeting a grid rule. We call them grids. Social Security Administration calls them grids, but technically they're listed in the materials, and you'll see them if you do any Google searches, as the medical vocational guidelines. The grids are not really applicable if you're under age 50 on your alleged onset date. Your onset date is the date that you either stopped working, or the date that your treating sources, your doctors and others, say that you're no longer able to work on a full-time basis. And please remember that we're never asking your doctor to say you are disabled. It's most persuasive to the Social Security Administration if your doctor outlines as I said earlier, outlines your medically determinable impairments and how those impairments limit your functionality. And Social Security Administration and the administrative law judges sometimes even get somewhat upset if they think we're trying to hang our hat on a statement from your physician, saying that you're disabled. They don't like that. They want the detailed explanation as to why, and they always, not always, but frequently then come back and say, no, that conclusion of just being disabled, that's reserved to the commissioner, and the administrative law judges are acting on behalf of the commissioner when they make a statement of that sort, because obviously the Social Security Administration's commissioner is not going to have time to listen to every hearing throughout the entire country. That's why we have administrative law judges. But to reiterate, if you're not at least 50 years of age on your alleged onset date, then you're not going to be approved on the basis of a grid rule, medical vocational guidelines. The third way to be approved is to have the agency or the administrative law judge make a finding that your RFC, your residual functional capacity, and that's a kind of a fancy way of saying what you can still do work-wise in terms of your functionality, given your medically determinable impairments. And of course, Social Security utilizes that phrase a lot, a medically determinable impairment. That's just a kind of a fancy way of saying that your treating source, your doctor, they have to make that determination using generally accepted methodologies to make that medically determinable impairment finding. So that's very significant when it comes to whether or not you're going to be approved for Social Security disability. As a general rule, with regard to a finding of a residual functional capacity of less than sedentary, let me give you some background information a little bit. Sedentary is typically defined as being limited to about a 10-pound limitation. What one would normally think of in a typical office setting would be a good way to think about and look at a sedentary functionality. And so if a person is age 50 and they're limited to 50 or older to sedentary work, then that person should be approved based on the grid rules that we've been talking about. If that person is age 55 or older and they're limited to light work, the light work is typically defined, just think about it in terms of a 20-pound limitation. And we're always using, in disability hearings and findings, always using a gallon of milk as a frame of reference, because everybody that knows that a gallon of milk weighs about 8 pounds. And so that becomes kind of the frame of reference point with regard to these weight limitations. So if you don't meet a listing, as defined earlier, and if you are not able to find that the grid rules, medical vocational guidelines, are applicable in your case, then that limits us to focusing on substantiating that you're going to have a residual functional capacity that's less than sedentary, less than a 10-pound type limitation, as a result of a combination of your diagnoses and functional limitations. But when you think about preparing for your hearing, don't, like I said, don't jack yourself up, and don't worry about being nervous. And if you need to take a break, if you need to use the restroom during your hearing, say, hey, I need just a short timeout to step in the restroom. A lot of folks are taking medications that result in the need for more frequent trips to the restroom, particularly for urination. And actually, those are the kinds of things that'll help you be approved, because looking at it from the administrative law judge's point of view, if you're going to need additional breaks, in addition, they're typically a break in the morning, and then a break for a lunch period, and then another break in the afternoon. But if you're going to need more breaks in addition to those, then they may find that you're not able to work on a full-time basis in a competitive environment because of the obvious need to take more breaks than are typically authorized. If you're using a cane or any other kind of assistive device, the administrative law judge is going to look very carefully at whether or not they consider that to be a medically necessary assistive device. And so typically they will simply ask, if you're using a cane or a walker or crutches or anything of that sort, they'll simply ask, well, did your doctor prescribe that for you? Do you have a prescription for that? So if you don't have a prescription, do what you can to get a prescription, particularly if you're using a cane. And because the use of a cane, many sedentary jobs, for example, require good use of both hands. And if you need that cane for either ambulation or balance or both, that could be a significant factor that may help your path to approval. By the way, most hearings last not real long, about 45 minutes, maybe 45 minutes to an hour. I think most administrative law judges allot about 1 hour for a hearing. Right now, the overall averages, when I say overall, I'm talking about national averages. At present time, about 40% of the folks who go for a hearing are being approved. Now, our numbers are much better than that, of course, but you can think of that in terms of if an administrative law judge has 10 hearings in a day, which they don't have that many, but if they're seen for the sake of discussion, if they did, then 4 of those people on average would be approved, and 6 of those people would be denied or not approved. There are 3 basic parts to your hearing. Part number 1 is a discussion of your past work. Past work being the work that you have done in the past 15 years. And I prepared a more detailed YouTube on that particular issue and that particular topic, and I'll include a link for that, or you can find it in my YouTube library. So yeah, be sure to subscribe if you're interested in doing so. Also, always appreciate any thumbs up or any likes, just like the likes on Facebook. YouTube has a similar system, so everybody likes to have likes, and it's beneficial that for the representative that you do that. So the three parts to your hearing, and you will see when you look at my other YouTube related to your past work, but we will send you a copy of your detailed work history, because your goal and my goal is to get through that as fast as we can and to facilitate moving that ahead as fast as possible. It's best that we send you a copy of what the Social Security Administration has as far as your earnings records, and then you'll have some way to refer to what the Social Security Administration has, be able to take notes, how much lifting on each job, and how exertional it was in terms of being on your feet all day or a good part of the day, things of that type. But as I said, I've covered that in another video. The second part of your hearing is really the heart of the hearing, the real meat of the hearing, and that's what we like to really focus on. And those are the medical problems, your medical evidence of record that substantiate why you're not able to hold a full-time job. And so we want to spend the minimum amount of time on your work history, and so that we have more time to talk about that, because the more time we have to discuss your medical problems, the greater the probability of your approval. And then number three, the third part of your hearing is what we call the vocational expert portion of the hearing. And you don't need to worry about that part. That's a good time for you to kind of kick back, take a deep breath, relax for the essentially the balance of the hearing. So I take into care of that part in its entirety, and I've invested a lot of time and money in whole computer software programs and other things that help me analyze what the vocational expert is saying. And when we get to that portion of the hearing, in many ways, to you, it will sound like, since you're not familiar with it and have no reason to be, it'll sometimes sound like a foreign language in a sense. So you don't need to worry about that part. And then immediately after the hearing, if the vocational expert says anything that you and I disagree with, I will file a letter brief, prepare and then submit a letter brief to the administrative law judge, outlining and providing an analysis as to why you and I disagree with what the vocational expert said. And let me digress again, because we always have to have in the back of our minds what Social Security Administration calls the 5-step sequential evaluation. Step number one is whether or not you're working, and if you're working at what they call substantial gainful activity. As the phrase substantial gainful activity would imply, there are several elements to making that determination. Is the work substantial? Is there gainful activity? In other words, if you have a pension or something where you have passive income, then that's not considered substantial gainful activity. But as of January 1st, 2021, the dollar threshold for substantial gainful activity, SGA as it's abbreviated, is $1,310 per month, gross pay. Social Security makes all their determinations based on gross pay, not not take-home pay. You and I are interested in take-home pay because that's what you have left to pay your bills and living expenses with. But Social Security Administration has to base that finding on gross pay. Again, back to our outline of the five-step sequential evaluation. Step number one is the person working at substantial gainful activity. If they are, then that's it. Then you're not going to be approved. It's not going to go to the second step in the evaluation process. Second, does the applicant, the claimant, have severe impairments? Having a severe impairment is a relatively low threshold. It's a severe impairment is defined by the Social Security Administration as an impairment that more than minimally impacts your ability to work a full-time job. And then step number three, we've already talked about, do you meet a listing? And then if you don't, well, if you do meet the listing, then you're going to be found approved. You're going to be found disabled. But if you don't meet a listing, then we go to step four. Step four is the analysis of your past work. And again, I prepared a separate YouTube video on that topic. So we'll not take time to repeat that right now. I'll refer you or include a link to that separate video. And then step number 5 is if there's a finding essentially that you can't do any of your past work, the work you've done the last 15 years, then it moves to step 5, which is a determination. This is typically where the vocational expert testimony comes into play. And it's a determination as to whether or not jobs exist in the national economy, not in your city or your county, national economy, that given your mental, emotional, physical limitations, that you can perform that exist in significant numbers. And again, that's in the national economy, not your local area. And by the way, the Social Security Administration cannot consider and does not consider whether or not somebody would hire you. A disability determination is based entirely on whether or not you are physically, mentally, and emotionally able to work full-time or not able to do that. They're not able to consider necessarily whether or not you can't find transportation to work, things of that type. That's not really relevant to a determination as to whether or not you have the personal capability, functionally, physically, and mentally, to do full-time work, as an example. It's not unusual for the vocational expert to respond to a hypothetical question that the administrative law judge poses. And again, you don't need to worry too much about this because I take care of this portion of the hearing, but you need to be aware of it and be aware of how the system works. The administrative law judge, for example, is say, given a person the same age and education as our claimant here, Ms. Smith, and given the following limitations, person is limited to light work and can only occasionally stoop and things of that sort, and we'll list all of those. And then the vocational expert then will provide typically 3 jobs that they believe that, given those limitations, that the person would be able to perform. Again, that's where my experience and fortitude, if you will, perseverance, come into play with being able to prepare a meaningful letter brief delineating why you and I believe you're not able to do those jobs that the vocational expert listed at what we call step 5, the other work. So to briefly summarize the 5-step sequential evaluation, are you working in substantial gainful activity? Do you have severe impairments? Do you meet a listing? Do your impairments meet a listing or medically equal a listing? Number 4, are you able to perform any of the work you've done given your limitations? Any of the past work you've done in the last 15 years? And then finally, whether or not you're able to do any other work that exists in the national economy given your limitations. As a general rule, we do not receive a decision at hearing. Now, years ago, we used to receive more decisions at hearing, but unfortunately, those days are in the rearview mirror. Typically, in about 4 to 6 weeks after our hearing with an administrative law judge, we will receive a written decision. What you and I are looking for in the first sentence of that written decision is a phrase that says fully favorable. If it does, that means you're approved. If it says unfavorable, then you've been denied and we'll have to appeal to the next level, which is the appeals council. The other option would be a partially favorable, and a partially favorable simply means that the administrative law judge has decided to approve you, but not back to your original onset date, and typically then we'll have a much earlier, I'm sorry, not earlier, but a much later onset date. And the net effect of that typically is that you either receive no back pay or you receive a minimal amount of back pay. And you need to remember too that we're in this boat together, so to speak. If you receive no back pay, I receive no compensation. And if you receive minimal back pay, I receive minimal compensation. So this is not a one-way street. This is something that you and I are working together as a partnership and moving towards an approval for you. Each administrative law judge has kind of a different methodology, if you will. Some like to do most of the questioning. Others like for the representative like me to do the bulk of the questioning. And but just to give you some insight as to the kinds of things you're going to be asked. Of course, the first part of the hearing, the administrative law judge is going to ask you just the basics. Excuse me. By basics, I mean things like, your name, address, your date of birth, your social security number. They want to make sure they're talking with the right person, that sort of thing. Whether your living arrangement, do you live in a house? Do you live in an apartment? Are there steps that you need to walk up to either get into your house or get up to the second floor? What is your living arrangement? Do you live alone? Do you live with family members? Do you live with friends? That sort of thing. And that can become significant in the finding, because the other part of what is covered in a disability hearing is simply activities of daily living, and that's another thing the administrative law judge is looking at. If you have significant medically determined impairments and diagnoses that would limit you, but you're still able to do the things around the house that a person would normally be able to do. And by that we mean the cooking, the laundry, the house cleaning, and in some cases maybe even the yard work. And also related to that, do you have friends that you see on a regular basis? In other words, what's your social life like? And by social life, we mean we're talking about not only friends, but we're also talking about how you're able to function in a work setting. Um, so even though if you're thinking, well, gee, I have all these medically determinable impairments and all these diagnoses, I should definitely be approved. Well, unless you and I can show that you're not leading a quote normal life as a result of your problems, then you're not going to be approved. And a part of that determination is based on whether or not you're able to do the things I just mentioned around the house, or whether or not you have help in doing those, whether or not you're able to go out to shop for groceries or other things. And a lot of folks who have mental and emotional problems that they're dealing with will have such things, for example, as agoraphobia. If you look at the base definition of agoraphobia, it simply means fear of the marketplace. And it's not unusual for my clients to find themselves on the verge of maybe a panic attack, or they're just not comfortable at all in a setting where there are a lot of people, or a setting where they have to be surrounded by a lot of people, as one might find themselves in a shopping setting. But just a real quick summary examples of some of the questions that I will ask you. I'll ask you, of course, about the things we've been talking about, but in addition, just as examples, I will ask you about what the Social Security Administration calls exertional limitations. Exertional limitations in a thumbnail sketch are related to such things as sit, stand, walk, lift, carry, push, and pull. And so we'll ask you, on each of those, how long can you comfortably sit? How long can you comfortably stand? Notice the key word, comfortable. Are you able to lift, not only lift, but lift and carry a gallon of milk for at least up to a third of the workday? A third of a workday is a little bit more than 2 hours, not all at once, but spread over the 8-hour workday. And then we'll ask you about your ability to, for example, if you're on a job where you had to, or again, up to a third of that workday, which Social Security Administration defines as occasional. They define that as from 0 to up to 1/3 of the workday. So assuming 1/3 of the workday, if you're able to perform a job where you had to reach above shoulder level for a third of that workday, and then whether or not you're able to use foot controls, whether or not you're able to do a pushing and pulling type of activity up to a third of the workday. And again, remember, a third of the workday is a little more than 2 hours, but it's not all at once. It's spread over the 8-hour workday. I'll also ask you whether or not you're able to do things like stoop. Yeah, a good example of stooping, according to the revised handbook for analyzing jobs, would simply be the position a person is in if they're walking down the road picking up aluminum cans. And then I will ask you with your ability to maintain attention. I will say, assume hypothetically that you're on a factory setting on an assembly line where things are coming at you not real fast, but still on a steady basis, and how long you would be able to maintain attention in a setting like that. And always give consideration to the fact that a person's pain level can be a very significant element with regard to how long they're able to maintain attention. And as a generalization, according to some of the Social Security's regulations, if a person is not able to maintain attention for 2-hour segments, then they stand a good chance of being approved for Social Security disability benefits, because they're looking at it in terms of a typical work day. You know, you have a break in the morning, you have a lunch break, as I said earlier, and then you have a break in the afternoon. Those are all amount to about 2-hour segments. So you need to be able to maintain attention. That by attention is a little bit lower threshold than one might think, you know, when it comes to concentration, but be able to maintain a reasonable level of attention for 2-hour segments. If you're not, and you can document it, and your doctors have been able to document it, then you've greatly improved your odds of being approved for disability benefits. Those are examples of some of the questions that I will ask you during your disability hearing. Again, I can be reached at 800-900-4440 or by email. My email is simply wjhermann, 1R, 2 N's, HERMANN @gmail.com. And I'd appreciate it if you find this information beneficial to in the lower right hand corner of the YouTube to click on the subscribe button, and also to leave any comments or any suggestions that you may have for improvement, or whether or not you found this information helpful and beneficial to you. So I wish you the best of luck in your pursuit of disability benefits, and I thank you for watching this and for your attention. Thank you.